Hi, welcome to Constitutional Chats, hosted by me, Janine Turner,
and Cathy Gillespie,
with students
Dakare, Chatman,
and me, Tova, Kaplan.
Join us as we discuss hot topic issues with constitutional experts. It's sponsored by Constituting America.
Welcome to Constitutional Chats. My name is Janine Turner. I can't sit close today because of the sun. I'm an actress by trade. You can check all of that out at JanineTurner.com. But I am also the founder and co-president of Constituting America. Constituting America was launched in 2010. We've been in existence for almost over 10 years, almost 11, because we launched on President's Day of 2010. So we are thrilled to be here today and to offer you this fantastic program. I'm going to introduce our co-host. First, I'm going to tell you actually who our guest is, and I'll give his bio in just one moment. But once again, the topic is the Bill of Rights and You. And today it's the 6th, 7th, and 8th Amendments. And our special guest is Oakland County Circuit Court Judge and Patriot Week founder, Michael Warren, Judge Warren. He's a returning guest, and we're really lucky and thrilled to have him. And wait till you see what he's wearing. All righty. So first, I'm going to introduce the host here. Once again, I'm Janine Turner, and I also want to introduce Cathy Gillespie. Cathy Gillespie is co-president of Constituting America, and she is one of the 16 private citizens serving on the U.S. Semi-Quincentennial Commission. That's a really big deal, helping organize the celebration of our country's 250th birthday in 2026. Cathy is a former chief of staff on the Hill and former commissioner on the President's Commission on White House Fellows. Cathy, I know you want to say hello and thank our generous, fabulous, wonderful sponsor.
Yes, I want to thank our sponsor for today, Geyer Dibesland. We first met Geyer back in 2016 when we did a Founding Father Forum in Houston, and Geyer came and brought her family and has been such a great supporter of Constituting America ever since. She even did an event for us in her home, and she bought the Constitutional Chat sponsorship at our auction that just concluded last week. So Geyer, we thank you so much for all you do to help support our Constitution education programs.
Tova Love Kaplan. Well, yes, Tova Love Kaplan is now 17. She's been 16 for, why is my phone going off like this? She's been 16 forever and ever. And now she's 17 as of, I guess, 2 days ago. And we're so incredibly proud of her. She is from Chicago, Illinois. She's a 3-time winner of our We the Future contest. She's the National Youth Director of Constituting America and runs the Youth Advisory Board, like a CEO of a top 100 company, I might add. She is passionate about inspiring young people to know and use their constitutional rights, and expect to see Tova, I don't know, somewhere magnificent someday, perhaps Secretary of State, President of the United States. You never know. Welcome, Tova Love Kaplan.
Thank you so much, Janine, and thank you all for tuning in. It's amazing to have you. I can't believe we're so far along our journey. Like, we've literally been doing this since March. I think that's amazing. So obviously, Janine and Cathy and everyone at Constituting America works so hard to put on these amazing programs. So please help sponsor that through Giving Tuesday. That would really be amazing. And thank you to our sponsors for today.
Yes, exactly. Okay, the brilliant and wonderful Tova Love Kaplan. Now Dakare Chatman, who's on set, but he's incognito. So he's with us in voice only, sort of. Yes, yes. So Dakare Chatman is 18 years old. He's from North Carolina. He is Constituting America's student ambassador and serves on our Youth Advisory Board, and is a 2-time winner of Constituting America's We the Future contest for short film and PSA. Dakare is a working actor currently on Outer Banks set right now, and will be seen in season 2 of that series whenever all that is released. So Dakare Chatman, you are equally as brilliant. We're going to see you holding an Academy Award, a Tony, and an Emmy someday. I'm just sure of it. Say hello.
Hi, everyone. I'm so glad you're here. I'm so glad to be back. I've missed a couple chats, but I'm glad to be here. And thank you to our generous donors. And we hope you enjoyed today.
Yes. All right, Dakare. out there somewhere. We just can't see you. Ladies and gentlemen, drum roll, please. It's our special guest talking about the 6th, 7th, and 8th Amendments, the Honorable Michael Warren. And he was appointed to Michigan's Oakland County Circuit Court in December of 2002 and was named top judge of the decade by the International Association of Top Professionals. That's pretty cool. Top judge of the decade. Judge Warren, along with his daughter Leah, is the co-creator of Patriot Week. He is a former member of the Michigan State Board of Education and the host of the Patriot Lessons, American History and Civics podcast. Fantastic. Judge Warren is a great friend of Constituting America, having written essays for our 90-day studies. Please check those out. And has appeared before in our Constitutional Chat series on the Federalist Papers. So welcome, Judge Warren. We're thrilled to have you here, and we cannot wait to have to hear everything you have to say about the 6th, 7th, and 8th Amendments.
Well, thank you so much. I really am excited to be back here, and you have a fabulous team, and I appreciate being here on Giving Tuesday and all the efforts that you have done over a decade. You and Patriot Week were neck and neck. We started in 2009, you started in 2010. So great minds think alike, and I cannot wait to be in your movie. That's going to be fabulous. We're here to talk about 3 very important amendments to the United States Constitution. But before we can talk about the Constitution, we have to understand why we have one. And that brings us back to the Declaration of Independence. And I know that Constituting America had a 90-day series about the Declaration. So this is just a real quick primer. We hold these truths to be self-evident, that all men are created equal, that they're endowed by their Creator with certain unalienable rights, that among these are life, liberty, and the pursuit of happiness, and that to secure these rights, governments are instituted among men, deriving their just powers from the consent of the governed. That when any form of government becomes destructive to these ends, it is the right of the people to alter or abolish it and to establish new government, laying its foundation in such principles and organizing its powers in such forms that them shall seem most likely to affect their safety and happiness. Those words from the Declaration of Independence were revolutionary in 1776 and they're revolutionary today. Now, what we're talking about today are the 3 critical amendments to the Constitution. And just so that we're all on the same page, the Constitution was drafted in Philadelphia in 1787. It was then ratified in 1788. And then basically the first Congress that met, one of the big priorities they had was to add some amendments to protect the unalienable rights of the people. There was a big criticism when the Constitution was initially ratified and drafted that it didn't have a Bill of Rights. So Bill of Rights is a specific list of rights that the people have and that the government cannot take away from the people. In the words of the Declaration of Independence, those are called unalienable rights, which means that you're born with those rights just as being a human being. You have them. The government can't take them away, and unless you forfeit them, and we'll talk about that in just a second. And otherwise, to be a just and free government, the government needs to respect those unalienable rights. So alien or alienability means you can sell or transfer. So unalienable means you can't sell or transfer them, and they can't be taken away. Now, I'm a judge in Oakland County, Michigan, and I have I have 2 dockets, and one of them is a felony docket. And I have presided over 350 jury trials. The great bulk of those are criminal trials. And the first 2 of the 3 amendments we're going to talk about deals with the criminal side of the law. The other side of the law we call civil. So, and I've presided over many civil cases, and so that applies as well. What I do also applies as well to these amendments. So I have a lot of experience in connection with actually ensuring the unalienable rights of the people are protected during these kinds of trials and proceedings. Amendment 6 begins with in all criminal prosecutions. So just so that we're, especially for our younger kids, it might not be quite understandable what a criminal prosecution is versus something else. If someone allegedly commits a crime, so someone's accused of committing a crime, then that would be a criminal prosecution when they're brought to court and they're prosecuted by the by the people of the state or by the federal government to prove that they are guilty of that crime. So crimes are things like if you punch somebody in the nose, that's assault and battery. If you steal something, that's theft. If you shoplift something from a store, that's called retail fraud in Michigan. If you hurt somebody really bad, that's called aggravated assault. There's all kinds of crimes. And if you're convicted of the crime, then you can be punished by the government. So you can be fined. They can say you owe us a certain amount of money, or you can be put in jail. And some crimes are so terrible that you might go to jail for years and maybe even your entire life. And there's some states that allow what's called the death penalty, where somebody can be executed by the state. So it's really important that those trials are fair and that justice is being done in those trials, because we don't want to put somebody in jail that doesn't belong there. So the rights that it lists out in Amendment 6 are: the accused shall enjoy the right to a speedy and public trial. So a speedy trial means that you have to be brought to court and tried pretty quickly. Now, this is not like TV. In TV, somebody commits a crime, the police investigate it, they're arrested, and they're convicted at trial all in the same 45 minutes. That's not life, and that's not what we're talking about. We're talking about a crime happens, somebody is arrested, they might be put in jail, and then they have the right to be brought to justice and be tried, depending on the case and the circumstances and who's doing the prosecution. It's called 6 months to a year and a half to pick. So you can stay a pretty long time. If it's a very, very serious case, you might want more time to be able to prepare for your defense. There are a lot of countries in the world where there were not speedy trials, where people were arrested and they were put in jail and they just sat there and rotted. They never moved. They were never brought to trial, and they could be there for years and years and years and basically get sick or die in the jail waiting for their day in court. So we don't believe in that. We believe in a speedy trial. The next is a public trial. So there were and this happened in England. And remember, the Bill of Rights is designed specifically to address issues that the British did before we declared independence. They were abusing our rights. One was that some people were put in jail and weren't tried quickly, so that's speedy trial. A public trial would be a secret trial. The opposite of that would be a secret trial, right? So imagine you're thrown in jail, you rot for a long time in the jail, then they decide to bring you to trial, and they put you in a room, and there's nobody else there except for the prosecutor and the judge, and maybe a witness for the prosecutor. Your family can't see you, your friends can't see you, the press isn't there, nobody knows what's going on, and then you get convicted. And it could be a genuine trial where there's real witnesses and there's challenge to the evidence, or it could be what we call a show trial, which is where they go through the motions, they pretend like you might be innocent, but they know they're going to convict you anyway. Sometimes people call that a kangaroo court. To protect from that, all of our trials in the United States are in public. And so we accuse somebody of a crime, we get them their speedy trial, and then any member of the public can watch that case. So when I have trials, in those 350 trials, they're all open to the public. The media can come in and take notes. They can actually take photographs and film. The family members of the accused can come in, the friends, and then the victims. It's also important. People that are hurt by criminal defendants, their families can come in and support the victim. So that keeps the system honest and fair. The next says, so we have in all criminal prosecutions, we know what that is. The accused shall enjoy the right to a speedy trial. We know what that is, and a public trial. And that goes by an impartial jury. So in the United States, if you're going to be tried for a felony, which is a crime that you can be charged with you can be punished with more than a year in jail or prison, you have to have 12 people, a jury of your peers. That's what that's called. They bring them in from the street, not quite from the street, but they're randomly selected. They're brought in, and they all have to agree that you're guilty of the crime. So that's called a unanimous jury. If it's a less serious case, you might have 6 people, but at least in my courtroom, they're all felonies, so we have 12 people. It can't be 11 to 1. It can't be 10 to 1, 10 to 2. It's got to be 12 to nothing. They all agree that you're guilty, or it has to be 12 to nothing. They all find that you're not guilty. An impartial jury means that they're fair. They don't have any biases. They're not your best friend. They're not your grandparent. They're not the best friend of a witness who's accusing you of the crime. They don't work in the prosecutor's office, and the prosecutor is the one that's bringing the case against you. They have to be unconnected to the case. They can't be a witness. They can't have said, oh, I saw what that happened, and they're not impartial. They're a witness. So you have to make people that know nothing about the case and nothing about the people involved in the case to be there. And that was not the case. There used to be juries where basically the neighbors of the people that they were actually saw the case or they saw the event, and that they were not impartial. And so we've made sure that all of our juries are impartial. Then it says an impartial jury of the state and district wherein the crime has been committed. So let's say you're in New York City and a crime happens in New York City. They can't take you and accuse you of a crime and then have you tried in Los Angeles, California, or in Houston, Texas, or Detroit, Michigan. Oakland County is right above Detroit, Michigan. That would be unfair. The people of the state and of the municipality, the city, the county, whatever it is, have the right to have those cases tried there, as does the victim and as does the defendant. So there used to be a time in England where somebody was accused of a crime. I say in the United States, in the colonies, before the United States, they're accused of, let's say, smuggling. They wouldn't have a jury. They'd only have a judge. It would be in a closed courtroom. They had to wait for months, if not years. And then they would be shipped to Halifax, which is in Canada, or to England, in London, and be tried for the case. And so that was seen as a real punishment and oppression, even if the person was innocent. So that's very serious. So we have in all criminal prosecutions, we know what crime is. The accused, person that's being accused of having committed the crime, shall enjoy the right to a speedy and public trial by an impartial jury of the state and district wherein the crime shall be committed. Now, remember, if you're from Los Angeles and you commit a crime in New York, you have to be tried in New York. So it's where the crime is committed, which district shall have been previously ascertained by law. That just means they can't change where the courtroom is later after the crime, and to be informed of the nature and cause of the accusation. That's kind of awkward language. Basically, it means you have to know what the charges are when you're charged with a crime. And you might think, well, of course you're going to know. Absolutely not. There are many places where you're picked up off the street in the middle of the night, or maybe they kick down your door in your bedroom. They drag you to a prison. You're rot for a long time. They bring you to a judge in a closed courtroom, and they say, tell us why you're not guilty. And you're like, I don't even know what the charge is. You have to tell me what the charge is. I have to be able to defend myself. And like, you know what the charge is. Of course you know. You know that you're guilty. And then they'll use something vague like you're an enemy of the state, or you're an enemy of the party, or you've done something against the dictator or something like that. And that used to be a serious, still is in some countries, a very, very serious problem. So you have the right to know what the charges are. So the first thing that happens in my courtroom when a case comes to me, we have a document. In Michigan, we call it a general information, and it says the accused name, it's the people of the state of Michigan, the government, versus, we'll call it Jack Smith, and then it lists all the charges that Jack Smith is facing. They say, and it happened on this date, and it happened in this city. So we know you're being accused of a specific event, specific crimes, specific places, and specific times. If you've read some of the science fiction or futuristic books like 1984 or Brave New World, you'll see that they don't charge you with specific crimes. They don't charge you with specific places or times. They just give you this kind of blank, you've been arrested and you have to defend yourself. So we don't believe in that. We believe you have the right to know what the charges are. And the next phrase is, you have the right to be confronted with the witnesses against him. And you think, okay, that makes sense. If somebody saw the crime, then they have to come and testify about your alleged involvement in the crime. But it used to be the opposite. It used to be that the witnesses were secret. You didn't even know who accused you of the crime, and they could not be forced to testify. So imagine you're accused of a crime. You're put in a jail cell for a long time. They put you in a secret room. They have a judge and no jury. They don't tell you what the charges are, and they don't tell you who's accused you of the crime. Fundamentally unfair and unjust. So we make sure that the witnesses appear, and in fact, there could be, let's say, the prosecutor brings 2 or 3 witnesses, and they have them testify, and the defendant may say, well, there were 3 other witnesses. I want them to testify. And there have been many cases in my courtroom where the witnesses testify, and they are not seen as being truthful and honest, or they're not sure. And in our system, you have to be absolutely sure. You have to be what's called beyond a reasonable doubt. A reasonable doubt is a doubt that is reasonable based on fact and the evidence, not on speculation or conjecture. So if you have a doubt about what this person saw, what they thought they saw, maybe they were in a bad angle, maybe their memory is faded, maybe it was a long time ago, you have the right to bring them and challenge their honesty and accuracy. They might not be dishonest, they just might not remember right, or might not remember all the details, or maybe it was dark and they really didn't see who the person was, all those kinds of things. Then it continues to have compulsory process for obtaining witnesses in his favor. That's what I just said. The judge can order a witness to appear on behalf of the defendant. So the defendant doesn't have to go chase somebody down and beg them to testify. The judge says, you must testify. And then it says, and they have the assistance of counsel for his defense. So assistance of counsel means that you have a right to have a lawyer help you in the case to defend yourself. It used to be that you had the right to hire a lawyer. Now you have the right to have the state pay for a lawyer if you are poor and you don't have the money to do that. So there's a whole bundle of protections there in the Sixth Amendment to protect a fair and free trial for criminal defendants.
So I just want to ask some lightning round questions, like quick answers, and then we'll try to get 7 and 8 in, right? Because it's all so complicated. Okay, and then and then everyone gets to have their questions. So I don't want to hog, but I do have some quick questions. When it says here to be informed of the nature and cause of the accusation, that's habeas corpus, isn't it?
So habeas corpus is what you have the right as a criminal defendant to be brought to court. And so that's a little different. That kind of goes with the speedy and public trial. So it used to be they'd lock you up, and then you would say you have to prove why it's legal to keep me in jail, and that's what the writ of habeas corpus is about. And that's protected in another part of the Constitution.
But isn't habeas corpus where you get to know why you're there? So you go in front of the
that's
court,
part of it.
so they say this is why you're here. So that's the writ. It's like a written document that says this is what you're. So would that not be to be informed of the nature and cause of the accusation? Is that not the same thing? They work together.
The writ of habeas corpus means that you can ask a judge, you can have a judge order the sheriff or whoever's holding you to bring you to court and explain why you're in jail. And so yes, that would mean that they would also have to tell you what the accusations are, but it only applies if you're in jail. You can be accused of a crime and be out on bond, and you wouldn't have a right to habeas corpus. And you don't have a right to compel somebody to charge you.
When it says here to be informed of the nature and cause of the accusation, what is that then?
Right. So let's say you're not in jail. They just bring you in and they say, we're going to try you for a minor in possession of alcohol. You can't be put in jail for that as a kid in Michigan, okay? They can't bring you to the courthouse. They have to tell you, you're here because we're accusing you of minor possession of alcohol, but the kid is not in jail. So the difference is that if you're in jail, you can't be held indefinitely. That kind of goes with the speedy trial aspect, but the writ says you have to prove to the judge that you deserve to be in the jail.
Okay, so when it says here to be informed of the nature and cause of the accusation, it's two-pronged. One is if you're actually in jail, one is if you're at home. So there'll be different ways, and the writ is only if you're in jail, but there are two parts to that statement. Okay, I think I understand that now. Also, it's really interesting to me, you know, that they have to prove that you're innocent or guilty, all 12 unanimous. I think that's really interesting. That doesn't say that here. So where did they come up with that? When was that established, that there would be 12 most of the time and that it had to be unanimous? Where did that establishment, where was that established?
Actually, that's a great question, because historically in England, the jury slowly developed, and it took a long time. It's a lot longer than we've got to talk about here. But eventually it became practice that you needed 12 jurors to unanimously agree on a conviction. But there were some exceptions. And in fact, there were a couple states down south that, because, and this is just the terrible side of some history, they made it 10-2, because what was happening was they would get they were accusing African-Americans of crimes they didn't commit. The racists wanted to convict them. They get a couple of African-Americans on the jury pool, and then they wouldn't convict, right? And so then they changed the rules, so they made it 10-2. And then the U.S. Supreme Court just last year said, no, it has to be unanimous. So I was kind of going at a very high level, but it was a development in England over the course of several centuries, where the right to a jury began with, you couldn't accuse somebody of nobility of crime unless he had a jury of his peers. So it'd be nobles judging nobles.
Okay, yeah.
And eventually it spread to everybody else.
But the unanimous part was established by the Supreme Court?
Yes, just recently.
And so just recently? So are you saying in 48 of the 50 states it was unanimous pretty much, but in 2 it wasn't? So in other words, the states could decide if it.
Right. So in federal, so we have two states. We have 2 court systems. We have 51 court systems. So we have 50 state systems, and we have 1 federal system. So originally, Amendment 6 was talking only about the federal government. We passed the 14th Amendment. I'm sure you'll get to this eventually. And they incorporated the rights in the Bill of Rights against the states. But one of the very few they hadn't incorporated was the unanimous jury verdict. That literally just happened, like I said, a couple years ago. It's also interesting, or last year, I think. It's also interesting, it was like the Second Amendment. They didn't know that was also a question about, you know, how fundamental that was, and did it apply to states and all that. And that recently just happened too, within the last 10 years.
So I have so many other questions, but I'm going to toss it to Tova, and then we'll toss it very quickly, because we're against the clock here. But just so I understand, in the federal courts, if you had created a federal crime that was all over the entire nation, the federal courts, that was always unanimous? But in the state court? Okay, so where was that established? Where was that established in the federal courts that they would be unanimous? Where and when?
That was a Supreme Court decision based on the text of the Constitution. There isn't a requirement that it be unanimous. It's not specifically listed. There's another thing called the Due Process Clause, and the Due Process, which in here is Amendment 5, that people need due process of law, and that was interpreted to be a unanimous jury by the Supreme Court.
Interesting. So the Supreme Court established federally that it had to be unanimous, and then recently they established it had to be unanimous in the states.
Thank you. So, we all have the right to a speedy trial, as you really expertly laid out. But I've read a lot of articles about how, like, budget cuts or just not enough funding has meant that, as I'm sure you've experienced, judges have like huge caseloads that take a lot of time to get through, which increases wait times for trials. It's, the wait time for a trial has increased a lot over the years. So does this amendment give the government an obligation to provide enough funding to get through it quickly? Like, what exactly is Speedy? Can budget constraints kind of bypass this amendment is basically what I'm asking.
It's a great question. And the reality is we really don't have enough judges and a judicial system to process people as fast as they should. What happens is if you are accused of a crime and you're in jail and you haven't been tried within about a year and a half, then there's a presumption that you have been prejudiced by that and that the case should be dismissed. So up to a year and a half, that presumption doesn't kick in. So what that means, now we have, in Michigan, we're very blessed. We don't have this congestion problem that some other states have. And we have time guidelines that we're supposed to follow. And I'm supposed to get, they're an in custody defendant. They're supposed to be tried within a year. 100% of my cases, if for a defendant from charged to brought before my court to when they're tried, is supposed to be within a year. For all my cases, regardless if they're in custody or not in custody. If they're in custody, they want you to do it even faster. But other states that have this kind of crisis, what they end up doing is they end up letting people out of jail earlier. There might be a sentenced defendant that are supposed to serve a certain amount of time. They let them out so that there's less jail congestion, or they have to let out the defendants or dismiss their cases. So it becomes a real problem. But it's completely enforceable. The Constitution overrides all the budget stuff. If you don't comply, you get out.
Janine,
do you want to ask something else? Well, I just didn't know the prejudice part. How do they become? How does it becomes prejudice against whom? How?
The defendant, it's assumed that the defendant is prejudiced in his defense. So, because memories fade, evidence gets lost, those kinds of things. So part of the reason that we have a speedy trial is to make sure that the evidence is as good as it can be. And remember, this was passed back in 1791, and so they didn't have things like DNA analysis and those kinds of things. It was much easier to lose evidence or for memories to fade. They didn't have videos. They didn't have all this other stuff that makes it easier to preserve the evidence.
So if it's not done within a year and a half, it can obviously. So if you've committed a crime, you kind of hope they don't get to you for a year and a half because you might get dismissed.
Well, there's some people that are like that, right? So especially if they're facing really grave circumstances, like somebody is accused of armed robbery, they could be in prison for their life, or a minimum of 10 years or something. And so it's interesting, they often try to delay the trials, hoping that somebody will, a witness might disappear or some evidence might get lost. So there's this real tension between justice.
Yeah, okay. Yeah, that's really cool. Okay, moving on. So I guess we need to go to Dakare and Cathy very quickly. Unless Tova has another quick question. Tova, you have another lightning round? Okay. Dakare?
Yes, ma'am, I'm here. Hi, Judge Warren. Thank you for being here. I'm actually writing a paper in my criminal justice class, so it's good for me to know. I have a question about public defenders. Could you talk about how that works, like when the state gives you counsel?
Sure. So there's a couple of different systems. First off, any defendant that's accused of a crime has the right to hire their own lawyer. It doesn't have to be a government lawyer. You only have a right to a government lawyer if you don't have enough money to pay for one. If you don't have enough money to pay for one, then there's two ways that you get appointed. First off, you can always defend yourself too. And I've had defendants that want to defend themselves, and usually they hang themselves. There's an old adage that a lawyer that has himself as a client is a fool. But that happens. But if you get the lawyer, there's usually two ways that they're appointed. One is there's what's called an independent contractor, so they're not really part of the government. They're just lawyers who have a contract with the government, and then they come in and represent you. And then public defenders are employees of the government. So their job, that's all they do, is they represent criminal defendants, and they have an office, and they're just like any other employee of the government. So prosecutors are always employees of the government. They're hired by the government. They have to follow government rules. They get paid by the government. They have, if there's civil service or whatever, they're fall into that. Only some people that are defending criminal defendants are actually government employees, and so that's what we call public defenders. There's kind of a misperception that government lawyers are no good. I will say that some of the finest lawyers I've ever seen in action are lawyers who are defending criminal defendants who are paid by the government. So that I don't believe that at all. So you should be careful of that adage.
When did that change that from the Constitution here that it's, and this is like a lightning round 10-second answer, please. When did it change from to have the assistance for counsel from the defense to in other words, they could have assistance to, they could get it if they couldn't afford it? When did that change?
Right. So that there's a very famous case called Gideon versus Wainwright. And I don't know the date off the my tongue, but I believe it was in the 1950s, might have been the early 60s, where there was a case where Gideon was a defendant who defended himself, said, I wasn't smart enough to defend myself, I didn't know the law, and I should have had a lawyer, I couldn't afford one, and that should be part of the Constitution, right? And the Supreme Court agreed. So that Supreme Court decision changed the understanding of assistance of counsel.
Wow. So the Supreme Court has a lot to do with a lot of this. Okay, yeah. Cathy.
Hey, Judge Warren, we have a listener who wrote in and wanted to know, with COVID going on, some trials now are being conducted virtually, and how does that affect the public part of the trial? Can people still watch via Zoom, or if it's a virtual trial?
That is a fabulous question. So my kudos to the questioner. We have, I can only talk about Michigan and what I know about across the country, but we're Zooming now here in this call, right? I have Zoom for my courtroom, and you can go onto our website and learn how to participate in our Zoom. So tomorrow I'll be in court via Zoom, and members of the public can watch. So that's how, and some people have a YouTube station that's dedicated to them, and you can go watch their YouTube station. I don't do that because YouTube can monetize you. I don't think they should make money off of court proceedings, but that's how courts are dealing with it. So the access is through video.
That's a great opportunity for students to go on and watch some live trials. But we'll turn it back. Janine, would you like Judge Warren to go ahead and cover 7 and 8? Okay. Or
have 12 minutes, and we'd love to pepper that with the little questions. So how about a lightning round? What 7 and 8 mean, please? And you did a fantastic job. It's a lot to bite off, all of this.
Yeah. By the way, Gideon versus Wainwright is 1963, so I was pretty close. The 7th Amendment basically says that you have a right to a jury in a civil case, and that's basically the same thing I was talking about before about a right to jury. They don't have to be unanimous, and they don't have to have 12 people. So in a civil case, you're suing somebody because you think you were wronged. Let's say you're employed by somebody, they fire you, you think you were wrongly terminated, you sue them for wrongful termination. That would be decided by a jury. You'll see here it says in suits of common law where the value and controversy shall exceed $20. So back then $20 was a lot of money. Now it's not anything, but they didn't do a consumer price index to this, so that's the number. Most civil trials you don't need unanimous decisions. Usually, like in Michigan, it's 5 out of 6. Sometimes they can be 6 out of 8. It kind of just depends on the jurisdiction. And the one thing that's most people overlook here, but it says, and no fact tried by a jury shall be otherwise re-examined in any court of the United States. So in the trial, there's 2 main components. There's the law and there's the facts. So the judge is the law. I instruct the jury what the law is. I tell the lawyers what the law is. I run the courtroom in accordance with the law. Only evidence that's admissible under those rules can come in. But the facts, what happened in the case, that's up for the jury. And no judge can override the facts that the jury finds. So that's a protection of criminal defendants and others in civil cases where you can't have judges who disagree with the outcome of the jury decide to ignore what the jury's decision was. They're bound by it. Amendment 8 reads, excessive bail shall not be required or excessive fines imposed, nor cruel and unusual punishments inflicted. So bail means that if you're accused of a crime, so this is all criminal again, this doesn't apply in the civil context. If you're accused of a crime, instead of going to jail, or if you're in jail, to get out of jail, you post money. Posting means you give it to a government employee or somebody else and say, if I don't come back for my court proceedings, they can take that money. Sometimes it's really inexpensive. It might be $100, might be $50. It might be what's called personal bail, which means that you don't actually have to give the money up. You just say, your bail is $1,000. And if you don't show up, we have the right to take $1,000 from you. Sometimes it is 100% cash. We're not going to let you out unless you give us $1,000. Sometimes somebody else will vouch for you. That's called a surety. And sometimes you can put up a percentage. So in Michigan, it's common to have what we call 10%. So $2,000 cash surety or 10% means they can put up $200 and you can get out of jail. You can't give somebody $1 million bail for a speeding ticket. That would be excessive. You can't give somebody a $10 million bail for writing a bad check that was worth $50. So the idea is that you want it to be reasonably related to the seriousness of the offense. And again, in England and in other places where they were coming down and trying to hurt the colonists, they would say, okay, there's a minor offense, but we're gonna make your bail so high you can never get out. So that was one of the offenses that we wanted to fix with Amendment 8. Then it says nor excessive fines imposed. So you litter, you shouldn't be fined $25,000. You speed 5 miles over the speed limit, it shouldn't be a $100,000 fine. So the idea is we want them to be reasonably related to the gravity of the offense. Nor cruel or unusual punishments inflicted. So this is interesting. There used to be a time where people would get whipped, where they would get thumb screws into their thumb. They take screws and push them into their thumbs. They would be burned with hot pokers, all kinds of just gruesome things that they would do to people. They would drag people to death. They would do all kinds of really just awful things. And so cruel and unusual punishment is meant to stop that. It's interesting because under this amendment, it says cruel and unusual. And so some people says it can't, not only does it can be cruel, but it can't be unusual. Or excuse me, if it's cruel, that's okay, as long as it's not unusual as well. Or it's unusual, but it's not cruel, that's okay. So I make people write essays to reflect on their lives and what they've done and what they did wrong. That's pretty unusual, but it's not cruel. I mean, maybe the people that write them think it's cruel, but it's not cruel. And then other things, being stuck in a prison cell for 5 years might be cruel to some people, but it's not unusual. That happens all the time. So it stops from the government from being able to really hurt you in ways that are cruel or unusual. And that changes over time. So for example, if a punishment was common back in the 1790s, for example, you might have a huge fine, or you might stay in jail for a year, or there might be a death penalty on something we would consider today to be what? How could somebody get put to death for that? As times change, the meaning of this changes, and so that's one of the few areas where it's expected that the Constitution would change with the times.
Oh, that's really interesting. Okay, I'm gonna let Tova ask her question because she usually has to hop off for school. So Tova, lightning round on 7 and 8.
Yeah, so I have to leave after I ask the question, but I'll ask it quickly for the audience. What are the qualifications to be a juror, and how were these established? Were they established over time by the courts? Like, could you just talk about?
Great question. Normally, to be a juror, you have to be someone that resides within the district that the court is. So you can't be a juror. You can't be visiting from New York and serve on a New York jury. You have to actually be from New York. You have to be an adult, so you have to be 18. Normally, you have to be a citizen. I think some places you can be a legal resident alien. Like have a green card, be a long-term person, but I think usually it's a citizen, and that's pretty much it. The whole idea of a jury is to have people from across the community make these decisions. The people that decide that, at least in Michigan, we have a court rule that the Michigan Supreme Court passed, and it gives the specifics of who can serve. And then people can be disqualified if they know somebody, they're not physically fit, those kinds of things. But generally, it's very wide open.
Okay, I didn't catch your second question. I don't know if maybe do we answer that? Dakare, we only have 4 minutes. What's your lightning round question?
He had to go also.
Did we lose Dakare? Oh,
he had to
okay.
go also.
Cathy, I have two, but Cathy, go ahead.
Okay, one of our listeners is asking, and this goes back a little bit to the 6, but what happens if it's not unanimous among the jury?
Great question. So then you have, let's say it's 6-6, it's a split jury. We call that a deadlocked jury. And when you have a deadlocked jury, it's like the trial, and no one will ever move, right? So that there's no chance of it to be resolved. We call it mistrial. And it's like the trial never happened, and they can be tried again. So I've had that a few times where I've had people that, especially when it's a he said, she said case. So you're just dealing with the testimony of 2 people. That's the most likely place that you will have it. And then the prosecutor has to decide if they want to retry the case. The only thing that's different is that they would then have the transcripts they can use the transcripts from the first case in a second trial. A lot of people plead or they resolve the case and they don't have to go through a second trial. The chances of conviction go up very high when there is a retrial. So
interesting.
Yeah.
Okay, Janine, do you want to?
Is that it? Okay. I have 3 quick lightning round questions. 5, if it's a hung, what's a hung jury?
Yeah, same thing. Deadlock jury, hung jury, same thing. So that they cannot agree.
6 and 6. Okay.
It could be 6 and 6.
So,
it could be 11 and 1.
It says. Okay, it says in the 5th. I'm sorry. What were you saying? 11 and 1. What?
It could be, the split doesn't have to be 6 and 6. It could be 11 to 1. As long as you have one holdout. Remember, 12 angry men, one holdout. You don't have a unanimous jury.
That's considered a hung jury then?
Right. If the 1 will never bend to the 11, it's a hung. And I've had that. I've had 11 to 1. Yeah.
And then what's the other one though? And what's the mistrial then?
Well, I declared a mistrial when there's no chance that the jury will come to a unanimous agreement. Then we say.
So a mistrial, a hung jury, same thing.
Right. But well, you can have a mistrial for a lot of different reasons, but that's the one reason that a mistrial could happen is because of a hung jury.
Okay. Well, my 2 quick questions, and I have 2 others. If it's a mistrial or a hung jury, you're saying they could be tried again?
Yes.
So in the 5th Amendment, it says you can not twice be put in jeopardy. So how can that happen?
There's an exception. So when you have the hung jury, no decision has been made. And because no decision has been made, you're not considered to be put in jeopardy again. The double jeopardy clause deals with you've been tried on, let's say, the bank robbery on January 1st, 2010, and you're acquitted. And so you're done. And then they come back the next day and say, we're trying you for the bank robbery on January 1st, 2010. So wait a minute, I just went through that trial. They say, we don't care. So double jeopardy is designed to stop that. Not
Okay, double jeopardy.
Sometimes mistrials happen because of the defendant. So with the defendant causing the mistrial, then definitely no issue there. But if you're acquitted.
Say that again?
But if you're acquitted, so the jury finds that the prosecutor failed to prove you're guilty beyond a reasonable doubt, they can never try you again, and there's no appeal from that. The one time in the law where there's no appeal. Jury says.
Okay. So if they say you didn't do it, you're free to go. They cannot try you on that again.
Correct.
They can't take you to an appeals court.
That's
can't
right.
take you to an appeals court.
Yeah.
Okay. So when do you get to go to an appeals court?
Well, if you're convicted, in a criminal case, the only one that can, if you're convicted, or if in a civil case, either side can appeal. And sometimes,
so really quickly.
Yeah.
The facts here, it says the facts can't be used twice. But if it's a hung jury, they can use the same facts again. Did you mention that? Did you touch on that and I didn't catch it?
So that, right, so in the 7th Amendment, it says that the jury, a decision of the jury cannot be reversed on the facts, cannot be reversed by an appellate court. And that applies also in the criminal context. And so let's say the jury says, we find that the defendant, the charges that he stole $100,000 worth of stuff, and there's a lesser charge, let's say it's $10,000, and they find him guilty of the $10,000. You can't go up to the Court of Appeals and say, jury got it wrong. It really was $100,000. Judges can't say, no, they got it. They can't say, nope, we got it wrong. So that's to protect against that.
That's what we're talking about, facts. Okay.
Yeah.
Lastly, so in 7, and it's civil. That means not federal, right? So are they really just
criminal? Not criminal.
Okay, not criminal. So civil, are those more just like disputes? Like you took down a tree on my property. It's
Right.
more of a dispute.
Right. So you're not being charged with a crime. So a civil dispute would be like a breach of contract. Someone slips and falls in a retail store, medical malpractice, employment disputes, a dog bite, a car accident, all those kinds of things. Those are not criminal charges. Now, you could have a criminal charge and a civil charge, like in a civil case, like O.J. Simpson, right? He was accused of murder, was acquitted, but he was found liable for the deaths in the civil case. So that's not double jeopardy because he wasn't charged with a crime. He was charged with the civil liability. So that kind of really exposes the two different avenues that people can pursue redress.
Fascinating. So 7, when dealing with civil, can be federal or state.
Yes. Yes.
So is the O.J. Simpson the best federal example?
I don't remember. I think it was definitely tried by a California court in connection with the criminal case. I don't remember if his case was civil or criminal. Excuse me. The civil case was federal or state. Probably state, but I'm not sure. You don't have a lot of state civil cases unless there's people over state lines. So if you and I have a contract and I think you breached the contract and I'm in Michigan and I know you're an hour off, so you're not in my time zone. So I sue you. That's called, I could sue you in federal court if there's enough money at risk. It has to be $75,000. It's gotta be a lot of money. So that happens.
A federal civil court.
Right, federal civil court. That's right.
Because it's in 2 different states. But if it's all within the same state, it would be a state civil court.
Yes, yes, exactly.
Didn't we learn so much today? We learned so much. This is great. I'm really glad I'm doing this. My daughter's going to law school, and so now I'll be able to go, oh yeah. So Judge Warren, you are fantastic. Do we have any, we went over 4 or 5 minutes, but hopefully everybody was okay with that. You were terrific. A lot of pressure to do a lot of information in a short amount of time, but it was terrific. Just terrific. You're a real gem, and we thank you so very, very much for your brilliance and your dedication to being of service, right? To your state and
thank you.
your
The
country.
pleasure was all mine. I really appreciate the opportunity.